I'm Judge Puffenberger of the Lucas County Probate Court, and this session is going to deal with attorney fees. This is a very complex area where there are many factors to be considered, and once again, attorney fees are handled differently in different counties. So I'm going to talk today about how attorney fees are handled in Lucas County. And while attorney fees are paid in virtually every procedure that comes into the probate court, I'm going to focus mainly on attorney fees in estates and guardianships. There are also attorney fees involved with trusts, adoptions, and other things come before the court, but I'm going to focus mainly on estates and guardianships because those are the questions that come to our court most frequently. When you hire an attorney for any matter, to have a fee contract, to sit down with the attorney, put the contract in writing on exactly what's going to be performed and the cost that's going to be involved. So, for example, if you are named in a will as the executor of the estate of maybe your parent or grandparent, what you would do then, if you're named in the will as the executor, you have the right to hire the attorney. That's the person who hires the attorney. We call the fiduciary. That could be the person named in the will, or that could be another person appointed by the court as administrator. For example, if the decedent did not have a will, then you can apply to administer the estate, and other people can apply also. But if you are appointed as either the executor or the administrator of an estate, you are in control of the attorney, and you would handle the attorney fees. Actually, you'd handle all aspects on behalf of the estate. So in estates, there are several types of fees that you could be involved with. Number one, an attorney may want to provide services on an hourly basis, where they would provide their hourly fee, and they could give you an estimate on how many hours they think is involved in this case. That would certainly be an estimate, but their fee would be calculated on that dollar amount. And throughout Ohio and throughout the country, those ranges dramatically vary. If you're on the West Coast, attorney fees are substantially higher, or in New York City, East Coast. The Midwest, there are certainly pockets, maybe the larger metropolitan areas, attorneys charge more. In Toledo area, I'm talking off the top of my head, of course, but I think generally speaking, the fees that I see come in are between $200 and $400 an hour. That's generally the fees that we see. So you can hire an attorney on an hourly basis. And on that topic, I would say that certainly you could maybe always find a cheaper lawyer. You may be able to find a lawyer who just came out of law school, who's not experienced, that may be less expensive hourly than an experienced lawyer. You must look at the complexity of the case, and estates can vary greatly in their complexity. Some estates are very simple, where the decedent had some money in a bank account, maybe owned a home and that's about it, and there's one beneficiary. Well, that can be transferred fairly easily. Others are more complicated. Sometimes the decedent is involved in a business venture where they own 20% of a business or 50% of a business. And that's complicated because then we have to have an assessment of the value of that business. What are the decedent's assets in that business? How much should the estate receive as their part of the business? So that's one thing that could come forward. Also, we have decedents who own property in different states. Some people own international properties, and maybe they have assets overseas, and this can become very complicated. And in those situations, I would urge you to hire a more experienced lawyer who's been through some of those issues before, because they can be complex. And while the hourly rate might be higher, these would be attorneys that maybe could sift through that a lot quicker and get through that. You also have estates that could be contested. You have a situation where you have a will, and maybe there are 3 children, and one of them is ruled out of the will, is cut out of the will. Well, that could be a will contest situation, or a situation in which the decedent signed the will on their deathbed, and their disposition of their assets is not what we would call normal. They're not leaving everything equally to their next of kin. They're cutting some people out. Well, that could be complicated because they could be contested, and someone could contest that will. Someone could contest transfers that occurred at the later stages of someone's life, saying that they were incompetent, and that when they made the transfers, they should be declared invalid. So these issues come up, and they make estates much more complicated. So attorneys can give you an estimate on fees on an estate, but they have to make assumptions on what's going to happen. You don't really know if someone's going to contest the estate. You don't really know sometimes all the assets. You'd be surprised. We have children come in and say, gee, I never knew my dad owned a piece of land up in Upper Peninsula, Michigan. I never knew. They never talked about that. So you find out things after the estate is established. And so those things can happen too. So the fee can go up and down. There's also a possibility of, if you don't want to go hourly, you have the right to hire an attorney with a flat fee. Now these are generally the very simple estates where an attorney would say, okay, this is not a lot complicated. I don't see any complications coming. I will handle that estate for a certain amount of money, maybe $2,000, $3,000. I'll handle the estate, flat fee. Of course, you have to keep in mind that once again, that's based on the premise that is the estate. If you start finding out things later that, oh, there was a piece of property in France or Italy, this gets more complicated. But if the situation is such that you described to the lawyer when they took the case, the flat fee would apply, and that's what they get paid on the case. Also in estate cases, the third way to attorney receive fees is on a percentage basis. And the courts have a schedule on how much attorneys can receive based upon the amount of the assets. So it could be a certain percentage of the first $100,000, a certain lower percentage of the next $300,000. The percentages go down. And those percentages are found in our local rule 71.1. So you're on our website now looking at this website. Welcome, you can go on our website. We have our local rules. If you look at 71.1, it has those percentages. So some lawyers want to be hired on a percentage basis. Sometimes that works out for them. Sometimes their work is not as involved as it could be, but they still get a percentage as their fee. So those are the three. You could have an hourly fee, a flat fee, or a percentage fee. The court normally needs to approve any fee by an executor or an attorney. They cannot receive fees without court approval. There's an application made for fees. Generally speaking, if the executor approves those fees, the court will most likely go along with that fee also. If the executor objects to the fee, the executor says, oh no, the lawyer told me it was going to be lower than that, and I think this is an excessive fee, the court will schedule that for hearing, and we will determine whether or not that is a proper fee based upon the complexity of the case, the experience of the attorney, the amount of assets involved, and different other factors. So the court could schedule those matters for hearing if there's a dispute over the fee. In guardianship cases, generally speaking, yes, the fee is generally on a percentage basis. And that has to do with how much money is coming into the estate every year and how much is expended. So once again, in our local rules, we have a percentage where an attorney can receive a certain amount based upon how much money is received and how much money is expended every year in the estate. And there are exceptions to that, I guess, exceptions to everything. The court will approve initial costs for setting up a guardianship. So if an attorney sets up a guardianship, they have a certain amount of time involved in creating the paperwork and filing and maybe have a hearing. The court will approve those fees upon the filing of the inventory. In other fees in guardianship cases, attorneys can only receive fees on an annual basis. When the annual report is filed, we require an annual report. So when that annual report is filed, that's when the attorney can file for fees and also file for fiduciary fees. If you're the guardian of a ward, you only get guardianship compensation when the annual account is filed. So in summary, let me say about attorney fees. And that is, number one, you need to be certain of what fee is going to be charged. You need to discuss that with the lawyer. You need to get a fee contract in writing. I would urge that in every matter you deal with an attorney on any topic. You should have a fee agreement in writing. And secondly, you should stay on top of that, stay in contact with the lawyer and say, how's the estate going? What's next? What needs to be filed? What have you filed? Do you need documents from me? What do you need? Where are we on the fees? How's it coming along? Is it about what you expected? Is it about the hours you expected to expend to resolve this estate? Are we on target? Where are we? So I would say make sure everything is upfront in a fee contract, and secondly, monitor that during the time the estate is proceeding through the court.